Got a question here asking if the landlord didn't provide an annual renewal of the rental agreement, where does that tenant stand? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, even though a landlord may not offer a renewed rental agreement, right, and the lease is up, if a landlord and tenant agree otherwise to extend the tenancy, and usually the way they do this is tenant pays the rent beyond the lease term, right, and the landlord accepts that rent. The law under Civil Code Section 1945 presumes that the rental agreement continues on a month-to-month basis once rent is accepted, okay, and that on the same terms and conditions of the original lease, okay. Many leases actually operate pursuant to the presumption under Civil Code Section 1945 if rent is accepted, and usually that's a lot of parties end up, continuing on their tenancy on a month-to-month basis in that form and fashion, okay. Now, as to increasing the rent, this question was, I think, in response to how much rent a landlord can increase the rent. As you all probably heard on a lot of these questions here, that question is really going to depend on the locality of where the property is at, what type of tenancy the tenancy is at. If it's for example, an owner of an apartment complex is probably going to be subject to at least statewide rent and eviction control under the Tenants Protection Act of 2019. Might be subject to a local ordinance with more stringent requirements, that type of deal. So your rental increase, how much the rent can be raised, will vary greatly depending on if you're subject to the protections of the Tenants Protection Act at the state level or some type of local rent control ordinance, okay? That being said, the landlord can raise the rent generally, and that usually has to be done pursuant to Civil Code Section 827B for residential tenancies, okay? The landlord would have to provide at least a 30-day notice, and if that notice is mailed, there's 5 days that are added additional to that. Generally speaking, at least under the Tenant Protection Act, basically a landlord is permitted to raise the rent no more than twice in any 12-month period of time, up to the maximum rent limits prescribed in the Tenants Protection Act, which is basically 5% plus the percentage and change in CPI, and that varies depending on what metro you live in within California. There's, I believe, 4 metro areas, and then if your house or property is not covered in a metro area, as produced by the Federal Consumer Price Index, California averages the 4 areas, and you use the all California number. So that number changes every year. Usually the numbers come out between June and July of the year they're published, and that's the maximum rent that can be charged, basically. So mileage is going to vary depending on your circumstances, and you're going to have to check your local listings to see what the maximum rent is, basically. But just because you don't have a renewed rental agreement doesn't mean that a landlord can raise the rent. They can always do a change of terms of tenancy. And if you're in a local rent controlled area, you're going to have to check your local listings there too, because you might have to, be registered with the local rent board and, give notices to the board and make sure that your rental increases don't violate your local ordinance here. So always best to consult with counsel when doing rental increases, particularly if you're in a rent controlled area, basically. Landlords, if you're in the Northern California area and you need help doing rental increases, feel free to reach out. We might be able to help out. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.